So this is a very important law for us, for the courts, but more importantly, for the safety of the community.
8 on Your Side exposed the revolving door of Florida's juvenile justice system, but a big change is coming in just days. Florida's top cops told us the problem was how long you could legally detain an accused teen criminal before trial.
The old deadline, 21 days. If the trial did not start by then the teen would go free. Well, now there is a new law that gives judges more options. 8 on Your Side investigator Mahsa Saeidi is here to explain.
Keith, Jen, this law impacts a very small group of teenagers, only the most serious repeat offenders. Law enforcement tells me it's a game changer. March 2022, a deadly chase. Tampa's police chief said teens in a stolen car crashed, killing an innocent woman. And this was not their first arrest.
2 of the teens in the stolen vehicle were arrested just 5 days prior.
What went through your mind?
Deja vu, more of the same, because that prolific offender is not deterred by 21 days.
In Florida, on average, it takes 100 days for a juvenile case to go from arrest to trial. But the max you can hold most teens is 21 days. After that, the judge loses control. The teen is released, able to reoffend, while they wait for the next court date. Last year, Polk County Sheriff Grady Judd told me the decades-old law wasn't keeping up with our overloaded system. Now, effective July 1st, a new law, HB 7029, will give judges more discretion.
This law is for the prolific offender. This is the kid that's out robbing, shooting, drive-bys, and is very dangerous.
Does this make the public safer?
It makes the public remarkably safer.
This puts the judge back in the decision-making seat.
Pinellas Sheriff Bob Gualtieri was the driving force behind the new law. Here's how it works. A judge can hold a teen in custody more than 21 days if they commit a capital felony down to a third-degree felony. But the third-degree felony has to involve harm to someone else.
So it isn't even every crime.
What's excluded?
Burglary is an example with no weapon and no harm. So all the property crimes are excluded. The other thing that we put into the statute was encouraging the courts to continually reevaluate these kids. At the end of the day, the people of the state of Florida are going to be safer.
And you cannot endlessly lock up a teenager. Every 21 days, that teen is entitled to a hearing. If the judge determines they are a danger to the community or a flight risk, they have to explain why in writing. And after the 60-day mark, I'm told that the case will be expedited.
And again, this is for prolific crimes. I mean, you heard one sheriff talking about burglaries, but also car thefts. I mean, that's a big deal. There's a lot of crime in car thefts, but that's not included in this either, right?
Yeah, and that's interesting because that's a huge problem here in the Bay Area. But if you're just stealing a car, that crime would fall outside of this. And most teen criminals, they already know that, so we're not telling them something they don't know.
Right.